At the examination yuan, we do have an academy for government officials. We also have another training centers at different yuans, different branches of the government. As for human rights related training, the MOJ made a proposal that is right after the review meeting in March. We will base our training scheme on the concluding observations provided by the panel of experts. So first of all, we will have a review task force in each government agency which is responsible for continuous self-evaluation and improvement. There will also be a training task force. In the past, we organized workshops open to all officials from different government bodies. But in the future, we are going to have more tailor-made training programs for different departments. For example, there will be specific workshop on immigration for officials from the immigration agency. So the MOJ, by the end of this year, is going to draft training and teaching materials. And of course, we also want other departments to reference what we have completed. Again, there will be an evaluation task force. The evaluation results may have an impact on the budget and staffing of different departments. We believe this will help to implement the two covenants in different departments. Mr. Chairperson, distinguished experts, in terms of training in our number 153 to numbers 169 in the core documents, you will find out relevant information. At the MOJ, we serve as the coordinator for these training programs. In order to promote such training, starting in 2009, we drafted a training scheme and finished writing a handbook which can be used by instructors in workshops at different departments. In fact, we provided 12-hour training for government officials back then, but such training has been ongoing over these years, and every year we update the training and teaching materials. However, as mentioned before, so far the training has been general in nature. We know it's not enough. We need to tailor-make the training to the needs of different departments. That's why, as you heard, by the end of this year, we are going to finish drafting 5 teaching handbooks for various training programs. Thank you.
Thank you very much. Before giving the floor to your colleague, I'd like to just ask you, do you have special human rights training for police officers? Do you have special training called for judges? Do you have special? I didn't find anything in the core document on that. And for prison staff, not just the head of the civil service. Do you have a human rights instruction tailored to the specific needs of immigration officers in the towns at the local and at the regional level? Sorry, but you wanted to answer to the question before. I'm sorry, I didn't see you. You have the floor.
Thank you. Personnel Affairs Department, we are responsible for training of government officials and employees. When it comes to training related to human rights promotion, between the year 2010 to 2012, we organized workshops for trainees totaling 45,000. We also have online e-learning programs. We also have a website located in a local medical teaching center. Between 2009 to 2012, as many as 2.1 million government employees completed their online training on that particular website. And right now in this building, this particular training center also has its own website. As many as 70,000 government employees took training programs on this training center's website. So that's just some additional information for your reference.
Evaluation of what they're doing.
Yes, I wanted the same question. How do you evaluate the effectiveness? Is there a change in the way officers are now conducting their work? How do you know that, and how are you evaluating that? And secondly, is there gender sensitivity as a component of the human rights training? Not only gender sensitivity, but also sensitivity to minority groups, to migrants, indigenous people, all the intersectional issues that need to be addressed. How comprehensive is the training?
Okay. In terms of the online training programs, yes, indeed, evaluation is performed at the end. As for the actual changes in performing their duties, we are developing mechanisms to evaluate this matter, this dimension. And one of the experts said the gender sensitivity, whether it is included in the training. In fact, we have been working closely with the Department of Gender Equality of the Executive Yuan in drafting and designing these programs. So it's one of the key points we highlight in these training programs. As for issues related to indigenous peoples, minority groups, sensitivity training is also worthy of our attention. Many legislators gave us a lot of advice during the past session, so we have begun providing programs including these elements. Hopefully, more concrete efforts will be seen in the future, and the mindset of government employees will be changed too. I speak on behalf of the Ministry of the Interior, training for immigration officers and police officers. In addition to the general training on the issue of human rights and gender, yes, indeed, gender sensitivity is included. In addition to that, we also included domestic violence issues as well as minority or immigrants in the training for police officers and immigration officers. We know it's important to find champions in different departments, so we provide such training to the heads the department heads so that they can support their staff in implementing these human right protecting measures. We also train the mid-ranking and the file rank officers too. As for evaluation, we usually would rely on surveys or public opinions. In other words, we will use the annual survey at the end of this year to see whether the general public is pleased with the services they receive from these officers. As for the prison wards, I'll have my colleague to speak. For this prison workers, wardens, the Directorate General of Correction is the office I work for, so I am here to respond to your question. Our Directorate General has a training center for prison staff so that they know how to implement the two covenants. The MOJ has drafted the training handbooks, which are being used at our training center to train the prison staff. So we do attach great importance to safeguarding human rights, and we are working hard in this direction. Moreover, at this moment, in view of the inadequacy in existing laws and regulations, we are reviewing these laws, hoping to improve these inadequacies in the protection of the rights of the defendants. Thank you. At the training center, a couple of months ago, we began to provide training related to the rights and interests of indigenous peoples for government employees in charge of these matters. As for the CEDAW, after its implementation in 2012, the Department of Gender Equality has done a lot of work in training too. So I'll ask our representative to say a few words. Gender sensitivity training for government employees is included in the annual training hours required of government employees. So CEDAW came into effect in Taiwan since 2012. So my department has been organizing workshops to disseminate information about CEDAW. More than 2,000 government employees took part in these training programs. My department is also expanding the range and scope of these training programs to local governments. So another 20,000 government employees also took part in the training programs. We also worked with the Personnel Affairs Department in designing online training programs for CEDAW implementation.
Thank you very much. I think we must come to a close on this particular issue, but just to think, many countries have found it useful to follow the practice of the International Committee of the Red Cross in teaching on humanitarian law, using hypothetical cases to go through so that it becomes really practical, that they know what is happening in the various departments and everything. That's just a suggestion. We now come to the second issue, election reforms, very briefly, and then the nerve center, as you call it, media monopoly. On the election reform, very briefly.
I thought somebody was already here from the Election Commission. So if they could just tell us whether reforms have been, what are the new reforms that have been made in the last couple of years, and the law that keeps people out because of deposit, how does that work? Is it going to be changed? Is there anything being contemplated to change it?
I think there are two questions related to election practice. The first one about the, you mentioned earlier that every political party can participate in any election. That's regulated in our election law. And the question was, you mentioned about the political groups. Well, we don't have any possibility for political groups to run in elections, but they can run as a political party because it is very easy and very convenient for them to organize a political party. That's the first one. And then the second part of the question about deposit. We require that every candidate to put deposit certain amount of money before they run the election. The regulation is to guarantee that they genuinely reflect some voice in the society. If they obtain certain amount of the vote cast, then those deposits are returned to them after the election. And in addition to that, if they win enough votes, we would provide this money subsidy for their effort. So that's about the donation, the deposit. And so far, I have never heard any proposal to cancel the deposit. Although there are some suggestions by political groups, they say that they would like to see the abortion of those deposit regulation. But so far, I think the voice from the legislature, I don't think they have any strong support for that. Thank you.
How much is the deposit?
Local, like village head, it's about 15,000 New Taiwan dollars. That's about, I don't know if you can figure out that. If that's put that into US dollar, about 1,500 US dollars. Yes. 500? Okay.
Okay, let's not go into the technical details.
Okay.
Our time is very precious. Asma, perhaps you could...
Parliament member? It's $200,000 Taiwan dollars, I mean. Yeah.
That's quite a bit more. Okay. We now come to the next point, media monopoly. Would you like to ask you? Yeah, we can get the answer straight away from you. Who would like to answer? Yes, please.
In terms of freedom of press and freedom of media, well, in 2003, in order to protect the freedom of press, in our Broadcasting Act, we stated that political parties must not run media. Then in 2006, we established NCC, the National Communications Commission, which is an independent organization. This organization and its regulation stipulates that to encourage media convergence and to protect the journalist's freedom and to protect a competitive environment for the media, this organization will do whatever it can. And given this act and other broadcasting act, there are some limitations on who can run what media. For example, for cable stations, we stipulate that its market share must not exceed more than 1/3 of the total market. But in the past several years, there were quite a few mergers and acquisitions of media agencies. So in February this year, which is this month, to respond to civil society's calls, we draft another act to protect the pluralism and the freedom of the media. We also invite people from the industry, we invite scholars and experts and the civil society to input their opinions. And by June, we will submit our draft to the Legislative Yuan for their review.
Thank you very much. We now come to the fourth question, the role of the judiciary and particularly the independence of the judiciary. Oh, I'm going too fast. Yeah, but you know, time is running.
Time is running, but
okay.
this is one of the most fundamental questions confronting Taiwan democracy.
Go ahead. Sorry about, yeah, okay.
One question is this progress toward a new law going to interfere with the decision that's troubling so much of the public today about the purchase by the next group of the Jimmy Lai, etc. assets? Are these two related? Are they going to postpone an administrative decision until there's a new law? This is one of the most important questions confronting Taiwan in the last 25 years.
Okay, could I just, from the chair, indicate to you that we have 2 more days, and the group on civil and political rights has Article 10 to deal with, and to deal with the issue. But to have a general overview now is absolutely right. So perhaps I take your question as well, and then let them answer jointly.
Well, this question can also be undertaken under 10, but I will pose it now, and that is, in the new law, is it correct that there is draft law, the proposed one, there is a provision which provides for a compulsory right to reply? And I just want to know what is the rationale? How will that improve freedom of expression, information, etc. in the country? What is your rationale for that provision? Right, the compulsory right to reply. So, if
okay, who would like to begin? Thank you. You have the floor.
Thank you very much for your questions. From last year to this year, I have not seen too many civil events like this one. But from September last year, there were some debates on this act. Now, the current draft, I think there are 3 directions in this draft: short-term, the mid-term, and the long-term development. In terms of short-term, whether it is digital media or paper media, we want to make sure that there are plural opinions, and we don't want to see too many mergers or acquisitions. We want to see at least there are 6 to 7 different voices, so that they can compete against each other, so that we have enough freedom of press and journalism. In terms of our midterm objective, well, it is to protect the independence and the freedom of people who work in the industry. If there are no plural opinions, from the employees, then they will tend to be manipulated by the owners of the media agencies. Therefore, we regulate how the employees have the bargain power working against the owners of the media. And we plan to work through some civil organizations to improve the public education so that the general public understand how important this issue is. And we want them to have their channels to put forward their voices. So from the inner circle to the users, so the consumers of the media, we want to make sure that everyone can enjoy the freedom of press and journalism.
Okay, do you want to come back?
You forgot to answer Shanthi's question, that do you also have in that draft law that if the media has given out a news which is derogatory to someone, that they have a right to reply or a right to compensation or a right to amend the...
Right to reply.
Yeah.
Anybody can have...
Contradiction.
是目前的话，这
It is not done through this act. According to our Broadcasting Media Act, we already ask media to give the rights of the people who are criticized, to give them some opportunities to respond to media reports. If it is digital media. But as for paper media, there isn't such a provision. So now we are including this provision in the new act, the new draft act. But the paper media has some doubts. The print media has some doubts because the print media industry thinks the government is extending our power too much. Maybe it is going to induce some adverse influence on the independence of the industry. So it requires more debates still.
Was an answer given to my question about the relationship between the immediate decision involving the purchase of the next group by the want group, etc., and the new law? Are they related in some way, or will they proceed independently? So we may have a decision about the purchase that's so controversial now before we get the new law. I missed that. Has that question been answered?
And while you think about it, are you also looking at what other countries are doing in this respect?
Chairman, please don't distract people from answering my question. I don't hear an answer. There's no one in this broad group who can tell me this is a technical problem or is it a political problem? And if it's political, who decides?
我想这个应该不是一个政治性的议题。
I don't think it is a political issue because it is a legal and technical problem. And the freedom is guaranteed in our constitution. And the question brought about by Professor Cohen, you mentioned the next group, which includes Apple Daily. Well, the print media is not within the work scope of the NCC. It is within the scope of the Fair Trade Act. And I think the question is about the convergence or the concentration of speech monopoly. In the past, we adopt the UK model. we can't reject this project altogether immediately, but we can require the businesses which are to be merged or acquired to give us their promises, to promise that they will not influence public opinions, or they are not going to monopolize public opinions, so that we can draw a fine line to tell the enterprises which want to merge or acquire, to tell them that this is the line you cannot cross. So, well, in the past, we only had such provisions for digital media, but now we need to extend the regulations to apply to print media.
It's been widely reported that this whole transaction arises from the fact that Jimmy Lai gave up trying to get a cable station, and that he didn't have the political support required to get approval because his group so widely criticized everybody. In other words, he was too independent successfully to play ball in the Taiwan freedom of speech market. So I think it's a big loss to your market that this is occurring. And I'm wondering whether that report is accurate, that the market is closing because of political influences. It'd be good. This concerns freedom of speech and Taiwan's future.
Okay, who would like to answer to that comment, please?
换成一个原则啦，
I think we have the principle to protect the freedom of the press and to protect people's right to knowing about things. And the project you mentioned is a single case. It's not a systematic problem, and this case is now being reviewed by the Fair Trade Commission. So far, we don't have answers to that. I think our Fair Trade Commission will hear your voice from us, and they will continue their review.
Thank you very much. I have a feeling that the committee, particularly the one on the ICCPR, will come back to this issue tomorrow. But we're essentially this afternoon dealing with the common core document, the general question, which apply equally to both covenants. But Philip Alston, he raised another general question from this first section, please.
Thank you. Okay. I want to look at two issues, and these both arise in the context of the core document. And they are linked. The first concerns the extent to which the judiciary has actually made use of these two covenants that have been ratified, as you call it. This question was posed, and in the additional information there is reference to a very tiny number of cases. Now, I have to say this is not so unusual. The judiciary in many countries is reluctant, but so far the record in Taiwan does not indicate that the covenants have become an important element in legal determinations of cases. Second question, which is related to that but is more complicated, concerns economic, social and cultural rights. You may not have noticed, but the entire discussion so far has really been on civil and political rights. But one of the very encouraging aspects of the Taiwan approach is the equal recognition of these two types of rights. Your constitution is actually rather, well, I perhaps shouldn't put it in this way. I'm not a diplomat. I'm Australian instead. Those two things are not compatible. But your constitution comes from 1947, and of course it has been amended, but not the structure. And the structure, it really reflects an approach which was adopted in India, for example, at around the same time, whereby there are two different types of rights. You have Chapter 2 of the Constitution, which is rights and duties. You then have Chapter 13, which is fundamental national policies. In Chapter 2, only education is mentioned in terms of what some would say are real rights. You then have, under Chapter 13, a very broad range of statements of social policy, and some of them are very impressive, very detailed, relating to social security, relating to the treatment of people with disabilities, relating to housing, and so on. But in fact, there are no real rights in those provisions. They remain very open-ended statements of government goodwill towards individuals. And so I want to ask, what measures could be taken either at the constitutional level or at the legislative level to treat some of these economic and social rights as human rights? That would mean that there is some specific way in which an individual can make a claim, whether to a court or to an administrative body or somewhere else. But until that happens, these rights remain very vague and open-ended, and it's very hard to make that transition. I don't want to speak for too long, but I want to come back very briefly, just an illustration. When I raised the question of the Convention on the Rights of the Child, the response was that there are many provisions to protect children, and the word protect was used several times. Protection is not the same as a right. Those who have a right to assert their rights in both positive and negative ways. It's not simply a law which ensures that they are not abused in some way. So rights are very important. There are a number of constitutions, for example, which will recognize rights to housing. Housing is a complex issue. We will come to it, I'm sure, tomorrow. I know it is in Taiwan also. But if there were a constitutional provision or some legislative provision recognizing that there is a right to housing, it transforms the debate at the national level. So I will leave my question at that. First of all, what can be done to encourage the courts to be more active in taking up the two covenants? And much more importantly for me, how can economic, social and cultural rights be given either constitutional or legislative status which treats them as human rights rather than ideal objectives?
Thank you. Who would like to answer? Okay, please.
Good afternoon, ladies and gentlemen. First of all, I would like to go back to one of the previous questions. That is the grand justices, the composition of grand justices. Our grand justices has a 10-year term. There are 15 of them, including the president and vice president of the Judicial Yuan. Who are these grand justices? They may be senior judges, scholars, law scholars, or reputable thought leaders with extensive executive or legislative experiences. But mostly, the grand justices are senior judges or scholars. Next, as to the grand justice interpretations citing the two covenants, there are a few examples. The first one is in 1995. When explaining whether the prosecutor has the right to detain the defendant, citation of the two covenants was made. And later, in 2004, in concluding remarks, the citation of the two covenants was also made. Now I would like to give the floor to my colleague. Good afternoon. To follow up on what my colleague just said, I would like to talk about the independence of judges. We do promote diversity in the composition of judges. The first track is through national examination. After passing the national examination, these to-be judges will have to go through training first. Another track is we have our own training center which will train future judges. For example, some prosecutors may choose to retool themselves to become judges. Then they have to come to our training centers. Senior lawyers, attorneys, after practicing law for some time, have an opportunity to receive training. If they have been selected by a dedicated selection committee to be eligible for such training and become judges in the future. So in the training process, we pay close attention to character education, in addition to professional training, as well as cultural sensitivity training. That's why we will work together with the Council of Indigenous Peoples to make sure that these to-be judges will have a clear understanding of these issues. Gender equality is another issue that we address and incorporate in these judge training programs. So that's so much about the composition of judges or the sources of judges. As for the politicized judge composition, I would like to reassure you that you don't need to worry about that, because once appointed as a judge should not participate in any political activities or take part in any political parties. So this is something they have to swear in when they take office. Moreover, if judges are found to be in serious violation of laws, they will be subject to the most stringent re-evaluation. So some judges may come to their post with their own baggage or family background, but once they become a judge, they are barred from taking part in political activities. As for the reference to the two covenants in their decisions, in fact, many judges at the administrative court the High Court or even District Court have indeed cited provisions in the two covenants in their decisions. There are basically three types of such reference. First, some judges simply referenced the provisions of the two covenants to be the basis on which he makes his decision. Sometimes another type is the judge may use the general comments in his decisions. The third type of reference is if sometimes the prosecutors use the ICCPR provisions in their indictment letters, the judges may refute if he thinks that provision does not apply in the case. In addition, in our training programs at the Ministry of Justice, we do include introduction to the two covenants too.
Thank you very much. Floor to
well, hang on.
Oh, sorry.
I would like an answer.
Yes.
It hasn't been given.
Okay. So the delegation still has the floor to answer the question.
这个两公约的
protection and the judicial decisions. Based on my own research, before we signed the two covenants, few judges would reference or cite the two covenants. Only one or two grand justices would reference the two covenants. But after the ratification, as many as 98 decisions that have referenced the two covenants, in particular, decisions made by the administrative courts, because that court deals extensively with the right to housing in the ICESCR. So we did not consider the two covenants as special laws or regulations that we should reference. But after the ratification, progress has been made. You can see more and more references are made to these two covenants. For example, general comments of the Human Rights Committee have been referenced more often than in the past. So this is something we are really pleased to report to you. I am the director of the Training Institute of the Ministry of Justice. So you ask about the composition of judges in Taiwan. In fact, we in Taiwan adopt the civil law system, so all judges will have to pass a national examination so as to become judges. I have been in this capacity for over 14 years. According to our survey, I found there's diverse background of all the trainees at my institute. In terms of age, they can be from 27-year-old to 45-year-olds. The same goes for educational attainment levels. Some are college graduates, some have doctoral degrees or joint degrees. You could find these trainees graduating from a wide range of universities too. So the core spirit of our training institute is that judges must be responsible and ethical, impartial, and independent in their practice. This is something we want to instill in our trainees. Thank you for your attention.
Thank you very much for those explanations. Are there any other questions that we still have about 15 minutes? Oh, the second question. The second question, and that was on right, the constitutional
Okay, I think this should be answered by the judiciary, but I happen to be a professor in a university, so I think I can answer your question. The chapter 2 in the we call old constitution. Actually, they are very abstractive, but it has some advantage there because in any case, individual can claim that an article of a law violate his rights guaranteed by the Constitution, and they can argue for their own interest. But the Council of Grand Justice have the final say by the way of interpretation of the Constitution. Does that answer your question?
No, but I won't insist because there is a well-known difference in other constitutional systems between rights which can be invoked. Your Constitution refers to various security rights, right not to be detained without charge or right to a fair trial. That can go to the great justices. My right under Chapter 2 has been violated. Please release me. If I say that the housing rights of my community are being ignored, it's not going to get me very far to go to the great justices and say, Chapter 13 says that the government shall do these various things. In all likelihood, if the great justices behave as most other constitutional courts do, they will say this is a matter for the government. It's not a matter that we as judges can take up. And so my question is there any possibility for the government, I presume that constitutional amendment is too difficult, but then the alternative would be to actually have legislation which recognizes some of the economic and social rights. That's my question. And maybe, you know, this is a policy question for the future, but I want to put it on the table now.
He wants to add something directly to that question.
I'm not so sure whether it's only a policy question. If I cite from the core document, paragraph 128, it says, after the act to implement the two covenants has been enacted to harmonize the country's municipal law with these international conventions, the human rights protection provisions that they contain have effectively become the municipal law and can be cited and applied directly in the court of law during litigations. Does that mean that if I feel I'm a victim, whether it's now the right to personal liberty or the right to housing, under any of the two covenants, if I feel I'm a victim by a governmental decision, can I directly say and litigate before the courts on the basis of Article 9 of the Covenant on Civil and Political Rights or Article 11 of the Covenant on Economic, Social and Cultural Rights? All the examples you are giving where courts have directly invoked any of these provisions refer to the Covenant on Civil and Political Rights. But have there been cases where people litigated directly invoking the Covenant on Economic, Social and Cultural Rights? Yes or no? And if no, why? Is it be seen by the judiciary as not being directly justiciable, or what are the reasons that would explain these differences?
No, okay.